Hi everyone, my name is Sarah Key. I am the conference editor for BJESL, as well as the co-organizer for Berkeley Law's Sports and Entertainment Law Conference. And today we have the honor to welcome Ms. Parsigian, Ms. Perez, and Mr. Anderson to share their thoughts on our panel, The Future of College Athletics Beyond NIL and Towards Employment Status. So for all of our panelists, we would love to hear a little bit about yourself and how did you become involved in sports law and what drew you to this area of practice in the first place? We can start with Mr. Anderson.
All right. Sure. Sounds good. Brian Anderson. I'm a partner at Sheppard Mullin, and I lead the firm's sports industry team. I've been working in sports for almost my entire career. My first project was working with Johnny Mosley and a group of people who wanted to put a professional ski and snowboard jump competition on Fillmore Street in San Francisco in the middle of summer. I was a second-year associate and helped with all the permitting and sponsorship and transactional stuff, commercial contracts, media rights, and all the aspects that went around that project. And from there, I've worked with teams and leagues and investors and governing bodies, mostly doing transactional work in the sports industry.
And Ms. Perez, please.
Hi, my name is Zathrina Perez. I'm of counsel here at Gibson, Dunn, Richter. I've kind of moved into the sports realm naturally from the work that I was doing. I started out at the firm doing general business, commercial litigation, and because of the experience that I built there, started tangentially representing entities and individuals in the sports field. One of the major notable sports cases that I did was representing Richard Sherman in his appeal of an anti-doping violation for Adderall under the NFL rules. And from that point, I just started moving into a variety of different areas in the field, representing sponsors, athletes, a wide variety of disputes. Currently just representing a number of leagues, including Live Golf, in connection with both their anti-doping regime as well as their player rules. In addition to representing on both sides in connection with sponsorship disputes. So it kind of naturally flowed from the work I was doing into the current breadth of work I'm doing in the sports field now.
Thank you. And last but not least, Ms. Parsigian.
Thank you. And you're pronouncing that right. So I'm Jeanifer Parsigian. I'm a partner at Winston and Strawn in our San Francisco office. And I got involved in sports law because of my work in antitrust. So I was an antitrust litigator. I am an antitrust litigator. And my first sports case was Alston v. NCAA, which was an antitrust lawsuit relating to college athlete compensation, which is a big part of what we're going to talk about today. Winston has a broad sports practice. We represent most of the major league players associations. So we do antitrust litigation, we do labor negotiations, collective bargaining, and have broadened into a lot of different types of litigation on behalf of athletes generally. So I came from an antitrust background, and I still do quite a bit of antitrust work. We're suing NASCAR at the moment for antitrust violations. So that's kind of how I've come at it to be where I am today.
Well, thank you so much. And the first question we have at BJESL is open to all the speakers. We're curious, how have you seen the legal landscape of college athletics evolved in the last 5 years? And what do you see as the biggest unresolved legal issue in college sports today?
Wow. I'll step in. That's a big question. I mean, there's been the last 5 years have been completely disruptive of college sports, and we've seen countless lawsuits, including Alston, which sort of paved the way for House and a lot of the other lawsuits that have followed. The biggest unresolved issue. Well, first of all, I think there's going to be a lot more litigation in the next 5 years, and the biggest unresolved issue. I mean, it's a tough one. I mean, I think, employment classification for athletes is obviously a big one, which is the topic of this conversation. And I'm sure we'll go into more more detail around that. I also think there's going to be, probably some regulation and probably litigation around NIL and collectives and payments for recruiting that are sort of dressed up as name, image, likeness licensing. So I think that's an unresolved issue at this point. So I think those two are probably come to mind as the biggest unresolved issues. I mean, I guess we also have to throw in, and Jeanifer, the antitrust, there's definitely going to be antitrust challenges, whether, there's an exemption at some point, and congressional action will be something we're all watching as well.
Yeah.
And
Oh, go ahead.
I'm sorry. Go ahead.
Well, I can go next if that's helpful. So I agree. Certainly, employment status is something that is being litigated in the courts and is a major issue that we're going to talk further about. I think, our settlement in the House case is still pending approval. And so whether that gets approved is an outstanding legal issue. But I think, if we move towards circumstances, and it seems like hopefully we are, my fingers crossed, our settlement gets approved in a couple of weeks, and athletes start getting payments directly from schools for their NILs, what sorts of regulations can happen around that? And is it governed by contract law? Does it create new antitrust issues? There's been a lot of litigation around things relating to the transfer portal and eligibility. And once athletes are kind of more directly paid by schools, what sort of issues does that create? And in what ways might the NCAA have some rules regarding player movements, other aspects of player restrictions that we do see in professional leagues where there's collective bargaining for those sorts of restrictions, but to what extent can those exist and pass antitrust scrutiny in the new environment after Alston, where the Supreme Court said that they were subject to antitrust scrutiny, but to what extent can they be justified, and what will that look like now that we've moved to a model where athletes will hopefully be getting paid by their institutions?
I'm happy to jump in on that as well. Definitely agree with what Brian and Jeanifer have been talking about. In addition, kind of from a rule-based perspective, the NCAA, the conference, its rules, its structure are really currently premised on defining and governing in the first instance the collegiate relationship with student athletes based on the traditional student athlete model. Once you start moving towards a model that is more professional based, meaning that student athletes get paid, and you start triggering other legal frameworks like employment law, labor law, even tax laws, when you start getting into issues relating to student athletes getting paid, then they're just going to have to kind of consider those. There's going to be a lot of open questions on how they restructure, reform to fit within these additional legal frameworks that are being triggered by, the change in the way student athletes are being treated, and that obviously has opens up a lot of questions as to what it's going to look like. Obviously, the NCAA and conferences have models that they can look at. The idea of athletes getting paid is far from novel. NBA, NFL, MLB already treat their athletes as employees, and as Jeanifer mentioned, a lot of the terms in which the athletes are working under are collectively bargained. So they have models in which they can look at as to how to kind of change the way they're structured, but that's definitely kind of one of the open questions and unanswered questions going forward. What is the NCAA really going to look like as we move away from the traditional student athlete model?
Yeah, so we talk a lot about student getting employee status. So what will be the biggest challenge for schools, athletes, and the governing bodies if students were to gain the overall employee status in the future?
I'm happy to jump in with some initial thoughts on this. For schools, I think number one, the biggest challenge will be financial, right? If student athletes get reclassified as employees, you have schools potentially facing hundreds of new employees on their payrolls. That's a financial, problem as well as a logistical problem. There's substantial costs associated with employment, including complying with minimum wage requirements, overtime pay, health insurance, other employment benefits. Moreover, schools are now going to, if student athletes are considered employees, they're going to now need to compete for athletes in terms of wages and employment benefits, in addition to the other offers and benefits that they traditionally use in order to entice student athletes to go to their school. So in reality, they'll need to pay out well above minimum wage requirements in order to attract top talent. And, the question is for the schools is where that money is going to come from. Many schools, college sports programs already operate at a loss. And any existing revenues that are being generated by sports programs are, already allocated to a variety of different, areas at the school and likely need to be used to support the school. So there's a real, potential here that if student athletes are reclassified, it could lead to schools facing really hard questions about whether or not they need to cut athletic programs, reduce athletic scholarships, reduce, rosters, or even make cuts to academic areas which had previously been supported by sports program revenues. With respect to the NCAA and the conferences, I think, what I previously said about, the NCAA needing to confront possible restructuring in order to fit into the new legal framework in which they're going to need to operate, which is, labor employment laws, I think would apply here. And then, kind of going to the last item that you mentioned, students, I think for the students, I would think one of the biggest challenges that they would face is the need for more self-management. In the current student athlete framework, a lot of the decisions for them are being made without their input. I mean, that's the reason how we got here, right? Because the schools are making decisions for them and, benefiting from their work without, getting their input or paying for their wages. As employees, however, if they're truly treated purely as employees, then the student athletes will be expected to regulate themselves in a number of ways. For example, responsibility of negotiating the terms and conditions of their employment, managing their wages and benefits, because the payments that they've received might be considered wages under tax laws, paying taxes, making investment decisions. These are all, what you usually start thinking about if you're not already working during your college years. You usually start thinking about after your college years once you, are fully employed. But now students, many of whom are working with full-time academic workloads, are going to have to balance a lot of these other issues as well, in addition to, balancing their rigorous athletic program. Moreover, if you really apply the employment framework in the student athletes model, a lot of the employment rules are more punitive. For example, just as an example, the anti-doping regime. If you compare the anti-doping regimes and again, just to back up for audience members who are not familiar with anti-doping, a lot of sports regimes typically have rules that prohibit or limit the ability to use certain substances, which they consider performance enhancing, and they have penalties for the use of those substances. The NCAA has a regime like that, and professional leagues have a regime like that. The NCAA regime is typically more accommodating, considering the status of students as student athletes. Once you move into a more employment framework, there is obviously a risk that, if you fully adopt, for example, an NBA or NFL model, that the regime that you'll be implementing is going to be a lot more punitive. And then the students, would have to would be required or have more responsibility to ensure that they know the rules and there's less room for leeway. So I think that would be, in my view, one of the challenges that students might face, that they're suddenly thrust into a regime in which they have a lot more responsibility and obligations without, having the proper training or experience for it.
So I am just also curious, is there gonna be like a potential middle ground solutions exist between a full unemployment status and the current NIL framework?
Well, I mean, I think we're approaching something that is like that with our settlement in the House case. I mean, the current state of NIL is that athletes are allowed to receive payments for name, image, and likeness from third parties, and that at the moment does include collectives who are generally supported by alumni and supporters of the school, which creates kind of a gray area. But the current framework is the idea that you can sell your name, image, and likeness to third parties to promote their products and services. So things like social media ads, endorsements, things of that nature. Once the settlement, hopefully, again, as plaintiffs there is approved, we're going to be entering a territory where schools have the ability to pay up to a certain amount to their athletes annually, which is for the use of their name, image, and likeness in institutional brand promotion. So the concept being that they're paying the athletes for the value that they bring to the school in marketing and things of that nature that really kind of enhance the brand value for the school. I think in ways that is a middle ground between what we currently have in the NIL framework and what an employment model would be like. It creates a market structure where schools can decide how much to pay athletes. They're allowed to pay athletes up to the cap that's contemplated, but the settlement doesn't address employment issues and all sorts of myriad legal issues that can come with that. So I think that is, in a sense, a middle ground. It has a lot of the issues that that some associate with employment status, things like they will be getting paid their money, and they will have responsibility for it, and schools will have to make decisions about how to recruit them and things of that nature. So I think it does incorporate some aspects of that while not getting all the way to legal status of employment. I don't know if it is a continuum on that in that way, or if it's just different, but that's where we're headed.
So I'm curious, how can universities prepare their students for this potential student athletes becoming employees, or how can students themselves to help them, get ready for this transition in the future?
Well, I actually think that goes back to the, how schools are impacted by this, which is really financially. It's going to be much more expensive to operate an athletic program, and I think part of that expense is going to be professionalization not only of the athletes but of the athletic department. And so I think we're going to see athletic departments hiring more professional coaches, like we've seen in North Carolina with Bill Belichick, general managers. They're going to look like a lot more like professional teams, but then that'll flow even deeper into the administration, where you'll probably have almost like in-house agencies. You'll have, I imagine schools are going to offer, as part of their recruiting, and also just because it's the right thing to do, education, training, planning, how these kids can invest their money and use it wisely. I think all that stuff will probably get captured inside the athletic department, which is great, and is important, but also, again, like increases the cost for these schools. And the negative side of that is, they're desperate for cash, and they're going to have to limit roster sizes or cut programs, or they're going to have to make some hard choices to provide this professional level of athlete and sport, but also like all the support and administration that really needs to go around that.
So I'm just curious, what would it mean for non-revenue sports? Would they also cut, like recruiting? Like how would that affect those type of sports?
Sure, I
Yeah, I
can.
mean, we talked about that already. Like, some of those sports will get cut, and we've seen that at local schools around the Bay Area, where entire programs have been cut, teams have been cut, limiting roster sizes, limiting scholarships. All those non-revenue sports are probably going to feel the brunt of that. But I think there could be some really cool things that come out of it too. You could see like certain sports where maybe they break away from the NCAA model and maybe like organize their own sort of league. And I think college soccer is a good example of that, where if you took all the best college programs and put them together and had Duke playing Stanford, playing Berkeley, playing UCLA, the men's teams, the women's teams, like that's great content, and they could go out and sell media rights, they could sell sponsorship. And so you could see certain sports that maybe are viewed as non-revenue in a certain perspective, but they have revenue potential where they could go out and do something like really innovative, and that could be a great thing for certain sports.
Also, I just thought of this question. So what would it mean for international students if we're moving toward employment status, especially under the current administration? How would they be affected by this transition?
So international students have a particular visa. They're usually not allowed to come over to work. So it would certainly impact the immigration status of how they would have to come over if they were deemed to be coming over in an employment capacity. I want to circle back a minute to the question about non-revenue sports to just share. I have kind of a different perspective. I think there's a concept of non-revenue sports that refers to sports that are not football and basketball. But I think there is an important distinction also between schools where athletic departments are revenue generating, which is a limited number of schools, though not as limited as we often think, and schools where no sports are really revenue generating. And I think that the schools where you see cuts are really more schools where none of the sports are really generating a lot of revenue. And those schools are making decisions about where to spend their dollars and invest in their programs. And it's based on their preferences of their alumni, and things like that. So it is, whether we like it or not, football is a popular sport. It tends to be thought of, and I think there's a lot of economic literature supporting this as something that has a front porch effect, where it's really good for the school in terms of raising brand awareness, raising popularity, and for alumni donations. So schools that are not revenue generating in their athletic departments may make decisions to prioritize football, prioritize basketball, or prioritize other sports that are simply more popular than others. And we see that happening. I think that at schools that are big schools that are revenue generating, where we do see athletic departments at the Power Four schools that are really all making millions of dollars and often hundreds of millions of dollars, we're a lot less likely to see any significant cuts. And cuts are likely to be, in a similar sense, at the preference of what is popular and what is not, and what they view as adding value to the university and what is not. Because at the moment, we're seeing those schools spend a ton of money on things other than non-revenue generating sports, on things like $10 million coaches' salaries and things like that. And Clemson famously has a gigantic $1 million slide for the football team. And I think we'll see a lot less of that sort of spending, and that spending get reverted to things like actually paying the players in those sports that generate the highest revenues.
So the NIL landscape has already led to conflicts over sponsorship deals, contract, and enforcement. And also, as we mentioned, if moving toward employment status is going to put a financial burden on schools. So what type of new disputes do you foresee arising if student athletes are classified as employees, besides financially?
Well, you'd have students would have a new legal framework in which to bring disputes, right? They would now be employees. They would be governed and have the rights of employees under various employment laws, which opens up avenues of new claims for them. For example, bringing claims for not complying with minimum wage laws, BLM rest break laws, open up areas of litigation for employment discrimination. So it would give them another tool which to use in order to assert their rights, because you're now operating within a new legal framework if they're classified as employees.
So Ms. Perez, I know you represent major corporate sponsors like Nike. So from a legal perspective, what are some key contractual provisions should student athletes and their representatives pay close attention to when negotiating NIL deals, and especially concerning the exclusivity terminating clauses and dispute resolutions?
Sure. Definitely the ones that you mentioned are important, and I definitely like to discuss those more. But I think the one that is most overlooked, while also being the most misunderstood by student athletes, or an issue that student athletes don't focus on as much, is the contractual term. That is how long the agreement lasts. From a sponsorship perspective, sponsors are often taking a gamble that rising stars in their college years continue to rise and ultimately become superstars. Accordingly, many of them might look to lock in an athlete into a longer term so they can capture some of that upside and make their sponsorship dollars worth it. On the other hand, many student athletes, are often just happy to get a sponsorship deal. They're not experienced with, having these types of agreements or entering any type of agreement at all. As a result, they might agree to a longer term without really thinking about it and taking the time to assess their development trajectory, whether or not, they're looking to go professional after college, their potential for new sponsorship opportunities if they continue to rise in their athletic performance. And they end up getting locked in these deals without having really thought about, what that means for their monetary potential going forward. You mentioned exclusivity. That's certainly another contractual provision that student athletes often don't carefully vet when they're entering into sponsorship contracts. The scope of exclusivity provisions can vary greatly, creating potential pitfalls for student athletes who don't really pay attention, who may not pay close attention to their scope. For example, let's take a sports clothing deal. The deal can require an athlete to wear the sponsor's clothes while playing on the field, or the deal can also require the athlete to wear the sponsor's clothes in connection with any sports-related appearance. So a lacrosse player who's posting pictures of themselves wearing a competing company's clothing at Topgolf with friends could potentially create contract issues. So, it's definitely something you need to look at when you're vetting a contract. Termination and dispute resolution provisions are certainly ones that you mentioned, and certainly additional contract provisions that student athletes should pay close attention to. Particularly in recent times, you're seeing NIL deals, including in the professional realm, increasingly including morality clauses that are very broad, which allows sponsors to terminate or suspend an agreement if the athlete's actions negatively impact the brand's reputation or goodwill. And student athletes may not, truly understand the scope of this. And also with sponsors in parallel taking increasingly broad views of their ability to terminate under morality clauses. With respect to dispute resolution provisions, definitely something to pay attention to. For example, you may have a California student athlete getting sponsored by a company based in Florida. Suddenly they are entering into agreements that may require them to litigate disputes in Florida with Florida law governing. And they might not fully understand that if they don't pay close attention to that. So, definitely one of the additional types of provisions that they should pay attention when negotiating a deal.
So then on the other hand, what are something that big sponsors like Nike would need to worry about as student athletes gain their employment status? Maybe they'll get more protection as employees. So yeah, how would that change the sponsorships from the sponsor?
Sure. I can't obviously talk specifically about Nike, but as a general matter, sponsors like Nike and other, clothing product companies typically have agreements where the relationship is an independent contractor relationship, right? So it wouldn't necessarily be inconsistent. Kind of just stepping back to give kind of a bird's eye view. When you're talking about sponsorship deals with third-party companies, these deals typically from the sponsor's perspective are a marketing tool, right? So what the sponsor is getting out of it is the ability to associate their brand and show their brand, on a person whose target audience is paying attention to and has a positive relationship to. So the sponsors usually ask, and there's some slight variations in this, but in the traditional athlete deal, sponsors typically ask for the ability to use name, image, and likeness, ask the athlete to participate in marketing and advertising campaigns, wear their gear, on the field while on playing in order to advance that marketing goal. But typically the relationship is structured in an independent contractor capacity and not as in an employment capacity. So if student athletes get reclassified as employees of the school, that wouldn't necessarily exclude them from also having sponsorship deals in which they're serving as independent contractors to clothing companies.
And going to Ms. Parsigian, I know you say you work a lot with the antitrust issues. So I'm curious, could you talk more about how does the current NIL rules intersecting with the ongoing antitrust concerns, and how would that change as they step into the employment status?
Well, it's a very hard question to answer. So the current NIL rules, as they stand, are in many ways a result of antitrust litigation that we have sued in Alston, and there was a prior case called O'Bannon addressing whether limitations on compensation that student athletes could receive, including for their name, image, and likeness, were violations of antitrust law. The current regime is a result of the Alston decision in the Supreme Court, which said that those rules could be subject to antitrust scrutiny, and simultaneously states changing their laws to require that student athletes be able to receive compensation for their name, image, and likeness. Those two events kind of forced the NCAA to change the regime. The current case that we're about to settle, House, also was filed before the change and the current regime existed, and was challenging this prohibition on student athletes receiving payments from third parties. In a world of employment, it doesn't really change antitrust issues. The only way that it could is that employees are able to collectively bargain. So you could see the development of a players' association or a union, and that would give antitrust immunity to any agreement that the union enters with the NCAA or with a conference or even at the school level, that would allow them to make more rules, have more restrictions on things like player movement, player compensation, and things like that without being subject to the antitrust laws. But antitrust will continue to be a vulnerability for any NCAA rulemaking if it's unreasonable. I mean, the main antitrust way of looking at it is whether it's a reasonable restraint of trade. There are plenty of rules of sports organizations that are generally thought to be reasonable restraints on things like scheduling, how you're going to play the game, referees, and a lot more than that. And when we get to a point where will the regulations that remain be considered to be more in that vein, that's going to exist whether or not there's employment status or not.
I think that Jeanifer, correct me if I'm wrong, but I think there's a part of the House settlement that also talks about reporting NIL deals to see if they're fair market value.
Yes.
Yeah. Okay. Good. You're here to check me on that. But I think a consequence of that could be we might see the value of NIL deals go down if there's if they're held to a standard of fair market value, because right now in the system there's a lot of NIL deals that are really sort of like compensation for recruiting and maybe not fair market value for the actual name, image, likeness, and marketing value that's tied up with it. So that could be an interesting consequence for NIL deals from the House settlement. And then on the sponsorship agreements, from the player's perspective, from the athlete's perspective, I think also like thinking about the tax. I don't think a lot of times they think about that, like allocating the fee for services versus the fee for the NIL license and how those are taxed differently. If you get in kind, if you get a bunch of gear, like first of all, like most NIL deals are like, I'm going to give you some free gear and you're going to go on Instagram and wear it and make it look cool. Like, they've got to pay taxes on the value of that stuff. And I'm not sure a lot of athletes like think about that or figure it out. So I think on the player side, like that's an issue to think about, taxes. And then on the brand side, again, like most of these NIL deals are not the big national global deals like Nike and Adidas and all the others. Like it's like the local car dealership. Like it's very local. And so like if you're doing a sponsorship deal with your local athlete and then he enters or she enters the transfer portal and goes to a different school, like that can really destroy the value of your NIL deal. So going to the earlier point about termination and thinking about those types of things that could happen in this new regime, like those are issues also to think about in NIL deals post all these like antitrust decisions.
Yeah, so Mr. Anderson, so I'm just curious because we have seen a wide variety of the size of the NIL packages, from just very modest endorsement to multi-million-dollar deals. So how do you think the differences between these packages are impacting college athletes? And I guess also going back to employment status, like as we mentioned before, the school is going to face difficult financial decisions, and how would that essentially change if it's going to?
Yeah, I mean, you ask really good questions, Sarah. It's a tough one to predict. I mean, I think I could see a world where it's sort of like haves and have-nots, and you get really big time, like basically like professional college sports. And then maybe there's a tier below that that's like more club level, but like still like what we think about as like college sports, which would be great. And that second level, like NIL would be massive for them, right? Like you get those local deals, they can make a little money, they can pay for their tuition. Like that's all beautiful. Like that's win-win. So I think it's going to be very complicated and messy, but like there's very clear pathways to where this could like all work out in a really good way. So I think you might see those NIL deals, sort of the long tail of college athletes who aren't like going to get the big national sponsorship deal. Like they could still do very well with these, with the sort of the NIL deals that we see now, and that could continue on.
And I also want to talk more about the anti-doping rules, as Ms. Perez just mentioned before. So I'm just curious, how is the employment model going to potentially impact the eligibility and the compliance enforcement for the anti-doping rules?
Sure. I mean, as we been talking about, basically by reclassifying student athletes as employees, you're, affixing an entire new legal framework upon the relationship between schools, the NCAA, the conferences, and student athletes. So you would definitely need to adjust the existing rules in order to address those. You mentioned eligibility and transfer. Some potentially applicable employment law rules include limitations on the ability of employers to prevent employees from getting other work, whether or not certain jurisdictions allow or don't allow non-compete clauses when a relationship terminates. So those are kind of like issues that exist when you superimpose an employment legal framework upon this relationship. But it's not entirely novel either, right? Because the NBA, NFL, the MLB, as we discussed before, they already treat and classify their athletes as employees. And with respect to the anti-doping regime, they've developed over the years fairly robust regimes, many of which were formed and continue to be subject to collective bargaining. In a lot of ways, it makes it, the collective bargaining of anti-doping regimes make it a little bit more fair. But on the other hand, when you shift from a student athlete model to an employment model, there's usually a lot more expectations that come about as a result of you becoming a professional. And as a result, some of the leeway that's been embedded into the NCAA rules to take into account the status of student athletes as students, may not be present when you shift to a more professional model.
And also, I just want to ask Ms. Parsigian. So I know you represent the, I'm sorry, give me 1 second. I know you represent the women national team in gender discrimination litigation, and I'm just also curious, how do you evaluate the potential for NL to either bridge the gender inequality in college athletics, and also how do you think the employment status would help bridge this equality as well?
So it's an interesting question. So in terms of NIL, I think that NIL has opened the door to women's sports in a lot of ways, getting individuals getting more money through endorsement deals, because you just have women who are popular, who have strong social media followings, and can really drive demand and can command high prices for their NIL value. If you're looking at how the House settlement will change and will allow direct school and payments to athletes, I think that it will generally not be that different. I mean, schools spend different amounts of money on women's teams than they do on men's teams at the moment. Whether or not that complies with Title IX is not clear, and not litigated that often. In employment status, you would have Title VII protection in addition to Title IX, which does provide some additional protection, I think, under case law. Whether that should be true based on just the language of the statute, I don't necessarily think it should be, but the Title VII case law is more protective, which could impact employment status. But certainly if our cases have been market-based antitrust cases, I think that the biggest key to ending gender discrimination is on the side of demand for the sports. And I think for a major reason why we were able to be so successful on behalf of the women's national team is because they're so popular and so compelling. And they drove audiences, they drove sponsors, interest, and that we have seen a huge increase in the popularity of women's sports. And that's really the key to the gender disparity is as audiences changing how we look at them.
So you mentioned like popularity of women's sports. So what about college athletes, like a female college athletes who are participating in a less popular sport? Like, how do you think they should approach this gender equality in sports?
Well, I mean, Title IX guarantees a certain amount of gender equality, right? It guarantees certain things like spots is roster spots is the primary way in which Title IX is enforced. The popularity of sports impacts everything. I mean, men's rowing is not going to command the sort of NIL payments from its institutions that men's basketball is. Right? That's just the reality of how it's working. And if you're moving to a market-based reality, women's gymnastics, women's volleyball, women's basketball are much more popular sports than women's field hockey and rowing at the moment. But those things evolve. And, it's just a reality if you're playing, if you're a rower. I don't know why I'm picking on rowers. But I don't think you're going into rowing and thinking that you're gonna be a professional rower, that there's a ton of money in it for you, because that's just the level of popularity of that sport in our culture. And that's true. As a lawyer, I'm never going to make as much as a pro basketball player either. So.
Well, thank you for answering that. That was just pure for my own curiosity. I was just wondering. And now I want to open up to all of the speakers. I am curious, this is very specific. What are some key takeaways from the Dartmouth men's basketball NLRB case regarding the employment debate?
Well, I can jump in with some initial thoughts. I mean, the fact that, they pursued their petition and then, made a decision, obviously after the election, to then withdraw the petition, at a minimum highlights how the student athlete debate on whether or not they should be classified as employees is wrapped up in broader national politics and positions relating to the role of unions and the expansiveness or scope of the coverage of labor laws. So I think at a minimum it is a prime example of how these issues really just go beyond the scope of what's appropriate in collegiate athletes, collegiate sports, and is wrapped up in broader politics.
Yeah, I would say I absolutely agree with that. And what it shows is how, in addition to the political issues, is how much of a challenge unionization would be in college sports when you have like a huge disparity across schools, across sports, and things like that. To come together and form some sort of broad union is going to face a lot of challenges in addition to the political ones.
Yeah, I don't have much to add to that. Agree completely.
Yeah.
And maybe just a timing issue, like maybe not the right time to the political point. So could see it come back soon.
Well, thank you. And for the time's sake, I just have one last question for all of you. And here at BJESL, we have a lot of peers who want to get into sports law after graduation. So I am curious, what are some advice or takeaways you have from your own successful career that you can give it to us and help us to get into this field of career?
I can jump in first. First of all, just do it. Like, do what you enjoy, because you'll be successful at it. You're more likely to be successful at it if you enjoy it. And I would say, really spend some time understanding the business of sports, not just the legal stuff. You can learn the legal stuff. There's lots of great lawyers out there, but I think where you can really separate yourself and add value is if you understand the economics behind governing bodies and leagues and teams and athletes, and where agents fit in, and media rights and sponsorship, and understanding how the money flows. Like, I feel like that's a really good way to separate yourself and set yourself up for success as a sports lawyer.
And I'll add, so sports law is really not one thing. It's not really just a single practice of law. Sports is an industry that has tons of different legal issues. There are tons of transaction, even on the transactional side, there's stadium financing, there's contracts, there's agent work, there's media rights negotiations. On the litigation side, there's antitrust, there's employment, there's bargaining. So there's a ton of different legal issues around sports, and you should think about what aspects of it appeal to you? I mean, do you want to work for a team itself that has a lot of like contract issues and is often really closely related to running their business? Do you want to be a litigator and do antitrust law and be practicing antitrust in the sports context? It can mean a lot of different things, and you should find what fits you.
I would definitely echo what Jeanifer said. There's one area of sports law where you're working for the space and the venue in which you're working is sports related. But the practice with respect to the practice of law, first of all, I would recommend, being a good lawyer, right? Developing your legal skills. And then you can transition into doing sports work, right? Because there's a lot of what would typically be traditional litigation that has a sports hook on it. There's a lot of what would traditionally be a typical transaction with a sports hook on it. For example, you might have a personal injuries case, but the personal injury case involves an athlete suing their coach. In the transaction world, you might have, a typical sale of real estate situation, but the real estate that is at issue is a soccer venue. So, honing your fundamental skills is important as a lawyer, and then transitioning into it, if you can't jump into the sports field, by finding legal work that has a sports hook, helps you transition a little bit easier into the field.
Well, thank you so much. It has been very helpful, and I learned a lot, and I know everyone at BJESL will have a great time watching our panel. And I just want to say thank you again, and I hope you have a great rest of your day.
Thank you, Sarah. Thank you
Thank
both.
you.
Great to meet you.
Thank you.